Citizens, you approach the court with a single question. How much will this cost? You calculate filing fees. You estimate attorney hours. You brace your finances. But you do not calculate the calendar. You do not prepare your nerves. You must have tolerance for uncertainty. Litigation is not a purchase. It is an enrollment in structure, procedure, and in sustained conflict governed by rules that do not bend to impatience. We do not count only dollars. We measure commitment.
When most people start thinking about filing a lawsuit, the first question they ask is simple. How much is this going to cost me? It's a reasonable question. Legal fees are real. Court costs are real. Nobody wants to step into a system blindly and be surprised by a bill they didn't expect. But that question, how much does it cost, only captures part of the reality. Because once litigation begins, you're not just spending money. You're spending time. You're spending attention. You're spending emotional energy. You're spending strategic flexibility. And sometimes you're committing years of your life to a structured conflict that does not move at your pace. A lawsuit is not a transaction. It's a process. And that process unfolds in stages that most people don't fully understand until they are already inside it. Many people enter litigation focused only on whether they are right, or whether they were wronged, or whether the other side deserves accountability. But the court system does not operate on feeling alone. It operates on rules, deadlines, burdens of proof, admissibility standards, and risk evaluation. All of that has cost attached to it. So let's step back and talk about what litigation really costs. Financially, strategically, emotionally, and in terms of risk. Not to discourage, not to dramatize, but to clarify. Because clarity matters before conflict becomes formal. Attorney fees are significant, but they are not the entire financial structure of a case. Litigation expenses accumulate across multiple categories, and they do so over time. The first financial layer begins at filing. Filing a civil complaint requires a filing fee. The amount varies by jurisdiction and court level, but it is rarely negligible. If counterclaims are filed, additional fees may apply. Certain motions may also carry filing costs. Once a complaint is filed, it must be properly served. Service of process often requires hiring a process server. If service is contested, repeated, or requires alternative methods approved by the court, costs increase. After initial pleadings, motion practice begins. Motions to dismiss, motions to compel, motions for protective orders, motions for summary judgment. Each requires attorney preparation time. That time translates into billing. Hearings require additional preparation and court attendance time. If hearings are recorded by a court reporter and transcripts are needed for reference or appeal, transcript preparation is an additional cost. Certified copies of court records may also be necessary. Then comes discovery. Discovery is frequently the most expensive phase of litigation. Written discovery requires drafting interrogatories, requests for production, and requests for admissions. Responses must be prepared carefully. Objections must be considered and articulated properly. This process requires time and review. Document production itself carries cost. Documents must be gathered, reviewed, organized, and sometimes redacted. In modern litigation, electronic discovery can significantly increase expenses. Large volumes of digital data must be collected, processed, searched, and reviewed. Specialized vendors may be involved. Their services are not inexpensive. Depositions introduce additional financial layers. Preparing for a deposition requires attorney time. Conducting the deposition requires attendance time. A court reporter must be present. Transcript preparation is billed separately. If the deposition is videotaped, video services add further cost. If travel is required, travel expenses apply. Expert witnesses, when necessary, represent one of the most substantial categories of litigation expense. Experts charge for review of materials, report preparation, consultations with counsel, and deposition or trial testimony. In technical or complex cases, expert fees can exceed other litigation expenses. As the case approaches trial, preparation intensifies. Exhibit preparation, demonstrative evidence, witness preparation sessions, pretrial conferences, all require focused time. Trial days themselves involve concentrated attorney hours. If a case proceeds to appeal, the financial structure expands again. Appellate briefs require extensive preparation. The record on appeal must be assembled. Transcripts must often be ordered in full. Oral argument preparation adds additional time. Litigation costs are cumulative. They do not occur all at once. They accumulate incrementally as the case progresses. There is also opportunity cost. Time spent managing litigation is time not spent elsewhere. For businesses, this may mean management time diverted from operations. For individuals, this may mean time away from work, personal commitments, or professional advancement. And recovery of attorney fees is not automatic in most civil cases. Some statutes provide for fee shifting. Some contracts include attorney fee provisions. In certain limited circumstances, courts may award fees. But absent statutory or contractual authority, each party often bears its own attorney fees regardless of outcome. That means even a prevailing party may not recover all litigation expenses. Money is measurable, but time is harder to calculate and is often more consequential. Civil litigation moves deliberately, not quickly. A case begins with pleadings, the complaint and response. Motions may follow. Briefing schedules are set. Hearings are scheduled based on court availability. Rulings may take additional time. Discovery deadlines are often measured in months. Depositions require coordination. Discovery disputes may require additional briefing and court intervention. As trial approaches, pretrial deadlines accumulate. Witness lists, exhibit lists, pretrial statements, and motions are submitted well in advance. Trial dates are often set far into the future due to crowded dockets. Continuances happen. Scheduling conflicts arise. Court calendars adjust. Appeals, if filed, introduce additional layers of time. Records must be prepared. Briefing schedules extend over months. Decisions may take significant time to issue. It is not unusual for civil litigation to span 1 to 3 years. In complex matters, it may extend beyond that. While the system's deliberate pace serves institutional purposes, fairness, procedural order, careful review, it creates prolonged exposure. As months pass, uncertainty remains unresolved. Even when little visible activity occurs, the case remains active in the background. Deadlines reappear. Preparation resumes. Strategy is reassessed. Litigation often moves in waves, periods of waiting followed by intense preparation. That rhythm can create sustained anticipation. Life does not pause while litigation proceeds. Work continues. Family responsibilities continue. Financial planning continues. Yet layered on top of normal life is structured uncertainty. And as time passes, leverage shifts. Costs increase. Evidence ages. Witness availability changes. Because time is not neutral. Litigation is often described as a search for truth. But operationally, it is structured conflict governed by rules, and where there are rules, there is strategy. Motions test legal sufficiency. They narrow issues. They frame arguments. Discovery shapes the informational landscape. Depositions assess credibility and lock in positions. From a non-lawyer's perspective, this can feel uncomfortable. It may seem that attention has shifted from what happened to how it is presented. It may feel technical in ways that seem detached from the underlying dispute. But this is not deviation from the system. It is the system functioning as designed. Litigation requires continuous evaluation. Each filing prompts reassessment. Each ruling reshapes probability. Each procedural stage introduces new variables. Timing influences leverage. Cost influences negotiation. Risk influences strategy. Arguments must be preserved at the proper time. Objections must be raised appropriately. Failure to follow procedural requirements can result in waiver. This layering of procedure and strategy requires sustained attention, which leads to the emotional cost, since even justified and valid litigation carries strain. Depositions are formal proceedings conducted under oath. Questions may challenge consistency. Preparation requires revisiting disputed events. Court filings are often public records. Allegations and responses may be accessible beyond the immediate parties. The presence of a pending case introduces ongoing uncertainty. Will the motion be granted? Will certain evidence be excluded? Will credibility be persuasive? Will an appeal change the result? Even during quiet periods, the case occupies mental space. Preparation requires reviewing documents and evaluating worst-case scenarios. That forward-looking risk assessment can be exhausting over time. Litigation can alter relationships. It can affect professional planning. It can delay personal decisions. Once a case is filed, control shifts to a structured system governed by procedural rules. Courts limit arguments to legally relevant issues. Evidence is filtered through admissibility standards. Personal context may feel central to a dispute, but may be legally irrelevant. When emotional expectations and procedural reality diverge, frustration increases and extended frustration becomes part of the cost, which brings us to risk. Feeling right and prevailing in court are not the same thing. The system allocates burdens. It defines admissibility. It sets standards for proof. Evidence must meet legal thresholds. Not all relevant information is admissible. Hearsay rules apply. Authentication requirements apply. Judges exercise discretion on evidentiary rulings and procedural matters. Juries assess credibility and interpret testimony. Outcomes are influenced not only by factual accuracy, but by how evidence is presented and how legal standards are applied. Appellate courts review records, not live testimony. They apply standards of review that often defer to trial courts on factual findings. Legal questions may receive less deference, but many issues are reviewed under constrained standards. Issues must be preserved properly. Arguments not raised at the appropriate time may be considered waived. This layered structure means reversal is not automatic simply because a party believes the result was incorrect. Even compelling cases contain uncertainty. Confidence is not evidence. Conviction is not proof. Risk is embedded in the system, and that risk explains why most civil cases resolve before trial. Settlement provides something litigation cannot guarantee: a controlled outcome. Settlement allows parties to exchange uncertainty for defined terms. Financial exposure becomes known. Resolution occurs on agreed conditions rather than imposed judgment. Settlement does not necessarily mean one side was wrong. It often reflects calculation. Parties weigh projected trial costs, probability of success, reputational considerations, and time exposure. They assess risk tolerance. As trial approaches, costs rise and risk becomes immediate. That clarity often motivates resolution. Settlement is not surrender. It is often risk management. But litigation is not always avoidable, and there are circumstances where it is necessary. When negotiations fail, when contractual obligations are ignored, when significant harm occurs and no voluntary remedy is offered, when injunctive relief is required to stop ongoing conduct. Courts exist to enforce rights when private resolution is not possible. The distinction is awareness. Entering litigation with realistic expectations is different from entering it impulsively. Litigation is not a tool for emotional validation. It is a mechanism for structured resolution, and it should be entered deliberately. Litigation is not a transaction. It is a commitment. A commitment of money, of time, of strategic energy, of emotional endurance, and of risk tolerance. Once a case is filed, the system takes over. Rules apply. Deadlines govern. Standards control outcomes. The real cost of litigation is not just the filing fee. It is the cumulative weight of structured conflict carried over time. Before entering that structure, ask a broader question than how much will this cost? Ask whether you are prepared for what the process requires. Because litigation is not a moment. It is a commitment.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.